Good evening, everyone, and thank you for joining us for tonight's webinar, The Musician's Guide to Copyright, Everything You Need to Know About Protecting Your Work with Bojana Bonkova. My name is Vanessa Esperanza Quintero, and I'm the Educational Programs Coordinator for CLA's Los Angeles office. I am looking forward to this evening's presentation and know that there are many artists, freelancers, and arts administrators in the audience. We are happy to welcome you to CLA. This workshop will provide songwriters and musicians with important information about how to protect your original music. You will learn the basics of copyright law, including the difference between protecting a composition and a sound recording, the rules and mechanical royalties required for performing covers, versions of others' copyrighted songs, and what is considered a fair use of others' copyrighted works. You will also learn about music licensing, synchronization, and the collections of public performance royalties in the US and Europe. For those of you who are not familiar with us, California Lawyers for the Arts, also known as CLA, is a statewide nonprofit organization serving the arts community by providing a number of legal and educational services across the state. I would also like to take a quick moment and share about the benefits of purchasing a membership with CLA and encourage you to consider joining as a member. Membership with California Lawyers for the Arts, you save 50% on educational programs, $15 on every referral fee, and enjoy discounts on our video on demand library of workshops and MCLE programs. You will also have free access to recorded workshops in our foundational series, which will cover fundamental intellectual property topics. With your support, CLA continues to provide critically needed legal, conflict resolution, and educational programs for artists and arts organizations throughout California, while vigorously advocating for the intrinsic value of the arts. To share a bit more about our programs and services, I'd like to play a short video from our Executive Director, Alma Robinson.
Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
If you are interested in knowing more about our upcoming workshops and about our social media, you could go ahead and follow our CLA social media platforms on Instagram and California Lawyers for the Arts on Facebook. I want to go ahead and invite Bojana, our speaker this evening, to join us on camera as I read a bit of an introduction. A native of Bulgaria, Bojana Bonkova has more than 15 years of international practice, experience, and expertise. The focus of Bojana Boyana Bokova's practice includes intellectual property and commercial law, with an emphasis on copyrights and trademarks, technology portfolios, data protection, cyber law, and entertainment law, both in the US and the European Union. In addition to her role at Sutter Law P.C., she continues to serve as the managing director of a successful international music publishing company, and in the past 7 years, she has been the manager and producer of the Grammy Award-winning artist, The Mystery of the Bulgarian Voices. Welcome, Boyana. We look forward to hearing what you have to say.
Thank you, Vanessa. Thank you for the kind introduction, and thank you for the kind invitation to join you tonight, and to everybody who is joining us tonight. Thank you very much. It is a pleasure to be with you. So, since I was invited to present generally on intellectual property rights of musicians, I'd like to start with a more general picture of what intellectual property is. It's referred to as everything that is creations of the mind is considered to be a product of intellectual property. This could be inventions, literary and artistic works, designs, symbols, names and images that they used in commerce. And now these different objects of intellectual property are protected by either copyright, patent, trademark, trade secrets, and then more specific information about which objects are protected by those branches of the intellectual property. Copyright law protects original works of authorship. So anything that is the creation of your mind, which is original, it means it should not be a copy of other person's work, is protected by copyright. On the other hand, patent law protects inventions and discovery. So this is a more technical subject matter, if I can say. It needs to be new. It needs to be something that did not exist before. So that's why it's an invention or discovery. And what patent law does and what patent is it protects the inventor in exchange for his disclosure of the invention. So with his patent application, the inventor discloses to other people who are skilled in his art how to make this invention or process that he's patenting. And in exchange for that, he receives patent protection, which is 20 years. A trademark law protects words, phrases, symbols, designs, logos, and it protects them because they identify the source of the goods and services of one enterprise or a company on the market. As an example, if you see a computer, you look at the brand, for instance, or another product. You look at the brand because you know that, for instance, Apple computers perform in a specific way. They use one operating system. They have certain features. On the other hand, you have Dell computers with different operating system and different features. So when you see the trademark of a product, you immediately associate this product with a specific producer, and you know that this product will meet certain quality. And that's why the trademark is important and it needs to be protected. Trade secrets protect confidential information. So this is any information in the company that is confidential and it is not disclosed because it has certain value. And this could be a process or a formula, for instance, a formula of mixing wine for the wine industry, or for instance, the Coca-Cola formula is a trade secret. It's known to a few people on the planet and they never board the same flight together just because they have to maintain that secret. I think that for musicians and creators of musical works, the most important of all those intellectual property rights is the copyright, just because of the nature of their creations. Copyright protects original works of authorship, as we already mentioned. They could be published or unpublished, and those works can be literary works, dramatic works, musicals, songs, movies, novels. There is no requirement for those works to be registered. As soon as they are created, they are protected by copyright law. There is only a minimum requirement of the work to be original, which means that it doesn't need to have to involve extremely artistic or imaginative skills, or it doesn't need to meet any certain criteria. It just needs to be original, which means it should not be a copy of another work that already exists. Just for avoidance of doubt, because a lot of people mix copyright protection with ideas, facts and other things that are not protected by copyright, I have listed things that are not protected by copyright. And these are facts, ideas, systems, methods, names. As an example, you may have an idea of a book or a song, but until you actually write that book or that song, it is not protected by copyright. You need to really sit down, fix it on a tangible medium of expression. Also, titles and slogans and short phrases are not protected by copyright. They can be protected by trademark. So, as I already mentioned, in order for the copyright protection to kick in, you need to fix your work on a tangible medium of expression. That means you have to write it down on something. It could be a recording. You can just literally write it down on a piece of paper or on your computer. As soon as this work is fixed, it's protected by copyright. And the term of protection kicks in. And the term of protection for copyrighted works, and now we're focusing mostly on works created in the US after January 1st, 1978. I'm focusing on those specific works just because in the US there has been multiple amendments to the Copyright Act, and the term of protection has changed a lot through the years. The term of protection that I am focusing on here is the one that's recognized by most countries in the world, Europe and South America, and it also protects the works created after January 1st, 1978. So the term of protection is the entire life of the author plus 70 years, which means that the work is protected for 70 years after the author dies. If the work is created by two or more authors, then that 70-year term starts after the death of the last surviving author. I think this is very important for musicians because very often music works are created by more than one person. For instance, members of a band, or even if you don't have members of a band, a lot of pop songs are written by two or three or more authors because one person composed the music, another person writes the lyrics. That's why it's very important to know the term of protection in this case. And another important thing I want to mention, and I will mention it later, when you have work created by different authors, you need to negotiate the exact percentage each author will claim in that song. I will touch upon this a little bit later. As an example, I can mention here George Gershwin, who passed away more than 70 years ago, but some of his works are still protected by copyright because some of his works he had a co-author. That was his brother, Ira Gershwin, who wrote the lyrics. Ira passed away much later than George, and that's why the works are still protected by copyright. The term of protection for anonymous works, pseudonymous works, and works made for hire is different. It's 95 years from the first publication or 120 years from the year of their creation, whichever expires first. So what exactly is copyright and what type of protection it gives you and what kind of rights it includes? So in the US, copyright owners have mostly economic rights. I have also mentioned moral rights here because in other countries, for instance, South America, Europe, and also other countries, authors have also moral rights. In the US, moral rights are given only to authors of visual arts only in certain cases. That's why I will mostly focus on economic rights. And it's like a bundle of rights that you have as a copyright owner. And these are the rights of reproduction, which allows you to make copies of your work. And this could be digital or physical copies, vinyls, CDs, or digital copies of your work. The right of distribution, which allows you or another person that you are licensed the right to distribute copies of the work. This could be physical distribution, digital distribution, a right to create or authorize derivative works, for instance, the right to create covers or to give somebody the right to use a sample of your work in another song, the right of public performance by means of digital transmission, and right of public display. On the other side, moral rights for authors of visual works only is in the US, these are the rights to claim authorship in the work. That means to be recognized as the author and to be able to put your name in the work. And the right to prevent intentional distortion or mutilation of the work. If you go to another country and have your work used there as a musician or a songwriter, you will be entitled to those rights. And I'm just mentioning for you to be aware that you have those rights because someday you might need to use them. When we talk about copyright in music, we talk about two different products or two different kinds of copyright. On the one side, we have copyright in the musical work or underlying composition, which usually comes first, because before you can record the song and have a performance, you need to actually write the song or the composition. The compositions or the songs are created by songwriters, composers, lyric writers. Sometimes this is one person, other times this is a group of 2, 3 or more persons. And the copyright owner of a musical work has the right to make and distribute copies of the work, to publicly perform the work and make derivative works from it. On the other side, we have the sound recordings. They're sometimes referred to as phonorecords. And what the phonorecords are, they're a series of musical, spoken or other sounds fixed in a recording medium, such as CD, vinyl, digital file. In practice, this is just a performance of musical work by an artist, which is recorded. When we talk about sound recordings, we talk about the right of the performing artist who performs the song and the music producer who arranges that recording process. So both of them have rights in that sound recording. The owners of the sound recording rights can authorize distribution, making copies of the works, and the right to distribute copies of the work. And they can also authorize derivative works. However, unlike the authors of copyrighting the underlying composition, owners of sound recording have only the public performance rights for sound recordings and digital audio transmissions only. So, in other words, owners of sound recordings cannot collect royalties from the public performance, from TV. We talk about terrestrial TV and radio, broadcasting radio. They can only collect royalties from digital audio transmissions from digital service providers. And this is not the case in other countries. I will mention more about it later. Who owns the copyright in the work? Traditionally, this could be the author or the creator of the work. So the person who creates it or writes it and fixes it on a tangible medium of expression. This could be a single author, 2 or more authors, or a group of authors when we talk about a collective work. If the author transfers his copyright to another person or a company or an enterprise, that company or a person is a transferee or assignee and becomes the actual owner of the copyright, even though that person or company did not create the work. So this is possible if the author signs a copyright assignment or a copyright transfer agreement. One example, for instance, in the music industry, this could be the music publisher, because many authors, most of the authors, work with music publishers and they sign publishing contracts with them. And what the publishing contract is an assignment of your copyright in the works in exchange for the services that publisher provides. And the author keeps receiving 50% of all revenue related to the works that he is assigning copyright into. And an important exception to the general rule of who owns the copyright in a work is when we have works made for hire. In those cases, the author, the work is not the individual who created the work, but the party that hired him. And this could be a company or an individual. There are 2 situations in which a work may be made for hire. One of them is when the work is created by an employee within the employment relationship between the employee and the employer. This is a very traditional case when we have an employment agreement and it's clear that the employer becomes an owner of the copyrighted work unless the agreement says otherwise. The other situation is when the creator of the work and the hiring party are not in an employment relationship. They sign a written agreement that has a work made for hire provision. In this case, in order for the work to be considered also a work made for hire, it needs to fall within a specific category of goods, of works, which is listed in the Copyright Act. So this could be a compilation, contribution to collective work, part of motion picture or audiovisual work, translation, supplementary work, etc. A very important note that I want to make for everybody who's based in California, and I assume that most of the people that are joining us tonight are based in California. Please be very careful when you put the work make or hire provision in a contract with a contractor who is not your employee. And the reason for that is that in California, once you have this provision in your contract with a service provider, you are immediately considered to be a statutory employer, and the creator is considered to be a statutory employee. And that may lead to certain employment law implications, such as you're expected and you're required actually to have workers' compensation, disability, and unemployment insurance for the creator of the work. And if you do not have those, you may be subject to criminal and civil penalties. So please, before you add this provision to the contract, think about it. You can talk to a lawyer, or there's other ways you can ensure that you have the copyright in the work. Just have a copyright assignment provision in your contract and you will be covered. As we already mentioned, once you create a work and you fix it on a tangible medium of expression, it is protected by copyright, and you do not need to do anything else for you to have copyright in that work. However, it is still very, very strongly recommended that you register your work with the Copyright Office. The reason for that, there are a few reasons for that. One of them is that once you register your copyright, that registration can be used as a public record that you have existing copyright in that work and that you are the owner of that copyright. Also, if your work is infringed by someone and your copyright is infringed, if your work is registered and you're in a lawsuit, you can claim statutory damages and attorney's fees if the litigation is successful, of course. Also, if you register your work within 5 years of publication, the registration is considered a prima facie evidence of the copyright validity in a court. It's best if you never reach the court, but sometimes it happens. So copyright registration is pretty easy and straightforward. There are a lot of resources on the US Copyright Office website. There are 2 forms that you can use for registration. One of them is performing arts form. You can use that form for compositions, and the other form is sound recordings, and you can use that for phonograms. The registration can be done both through submitting a paper form, or you can file the form online, which is cheaper because the filing fees in that case are lower. They're between $45 and $65 for a single work. And if you're filing a paper application, it's $125. So I recommend you to do this online if you're registering your works. And of course, there are a lot of resources you can read on the Copyright Office website, how to register your work. And if that's not clear, you can also talk to a lawyer. Lawyers also assist with copyright registrations. So you have your works that you created and you recorded, and what do you need to do in order to monetize your rights and to actually get paid for what you have created? One very important thing is to register your work with a collecting society, which collects public performance royalties. Such societies and organizations in the US are BMI, ASCAP, and CSAC. You need to be a member of one of those societies in order to collect royalties through them, and you also need to register your work. So when you register your works with those societies, you have to be extremely technical and list first all the co-authors that you have and the exact percentage of ownership each of you owns in a work, because these can vary. And in the best case scenario, you have to agree with your co-authors percentage that each of you owns in the song. And many bands actually fight over that. So on the other hand, you have bands like U2, which have agreed that each of the band members will get 25% in the song, irrespective of how much they contributed to a specific song. But other bands are not like that, so they fight over this a lot. So the way that public performance works is you submit your songs to the collecting society, and you have to update the list of songs. So the more you write, the more you register. And the collecting society matches your songs with the reports from users that they receive. This could be TV, radio, even concert promoters. And whenever your song is a statement or report from a music user, you get paid state royalty for that use. You can also collect mechanical royalties. In the US, mechanical royalties are collected by the Harry Fox agency or by music publishers. If you don't have a music publisher, you can register with the Harry Fox agency and collect royalties through them. In the US, the mechanical royalties are set, and their current rate, that's set by the statute. Their current rate is 9.1 cents per song. However, currently there are discussions for the increase because this rate has been fixed for a long term like this, and it hasn't changed for quite a while. And there are negotiations now to increase that rate to 12%. And one thing that I just forgot to mention what mechanical royalties are. They are owed for the reproduction of your composition. So every time somebody makes a copy and sells a copy of the composition, you are owed royalties. You can also collect royalties from digital service providers. And with the recent amendment to the Copyright Act, there is now a new nonprofit organization created, which is called the Mechanical Licensing Collective. It was designated by the US Copyright Office with the job to collect mechanical royalties from on-demand streaming services. And this rate is also set by the statute, and currently it is 15.1% of the streaming revenue. So on the previous slides, we focused on the money that owners of copyright and compositions can collect. Owners of copyright and phonorecords have less choice. They can only collect royalties from digital performance. In the US, those royalties are collected by an organization called Sound Exchange. They have been very active, and currently they collect royalties from over 3,600 digital service providers. These are streaming platforms, online radio stations. In order to collect royalties from them, if you're an artist or a label, you need to also become a member of Sound Exchange. Sound Exchange has contracts with similar international organizations in each country, in many countries of the world. And through them, they collect performance royalties for the artists and the labels from those countries. For instance, Belgium, UK, France, Germany, etc. As I mentioned earlier, owners of copyright and phonorecords do not collect performance royalties from broadcasting radio and TV. And this has been an ongoing battle for many, many years. For instance, even Frank Sinatra was trying to lobby for this amendment to be introduced in the Copyright Act. There is currently also amendment to the Copyright Act that interested parties are trying to enact, but it's still unclear if and when that will happen. This is why many foreign countries have not been collecting or distributing royalties for US artists and labels because they are trying to treat US companies reciprocally, meaning that even if they collect royalties, they do not send them to Sound Exchange for distribution because European artists and labels cannot collect performance royalties from radio and TV in the US. However, recently there was a decision of the European Courts of Justice which says that US artists and labels have to be treated the same way as the European ones. This is why they should be allowed to receive performance royalties from broadcasting TV and radio. So we might see some changes in the future in this regard. One very important tool for musicians on how to actually generate some revenue is synchronization. So what is synchronization? It is combining music with other type of content, usually audio-visual or visual work or audio content. And with the synchronization license, you grant license to somebody to use your work in a movie, commercial, or a similar product, video game, TV show. So who gets paid in case of synchronization? Usually both the owner of the copyright in the composition and the copyright in the phonorecord receive payment unless the sync only uses the song with a new performance, not with the original performance, but with a new one, which is either performed within a movie or just hire somebody else to perform the song. So in the industry, the copyright in the underlying composition sometimes is referred to as publishing rights, and the copyright in the phonorecord is referred to as master rights. And the reason for that is that very often, and in most cases, the rights in the underlying composition are administered by the publishing companies or the publishers, and the rights in the phonorecords are administered by the labels. And the labels are the ones who own the masters in a song, the master recording. And when the user wants to use a song for their audiovisual project, they need to contact the publisher and the master owner and clear their rights. Sometimes they might contact also an independent artist who controls or owns all the rights in the song. So this is the party who clears those rights for the user. So how to negotiate your usage and fee in case of synchronization? You have to pay attention to certain important matter in the request. You have to pay attention to specific terms. For instance, first of all, it's very important if the request is for a commercial, movie, TV show, or a video game. Usually the fees for commercials are higher because the usage there requires it to be so. If we have a movie which is independent with low budget, and for instance you have a movie produced by a graduating student, you will not be able to claim a very high fee. But if you have a movie with extremely big budget, then of course you can negotiate a higher fee for your song. The same with video games. They usually have good budgets for music. And you also need to pay attention to what type of media the audiovisual work will be distributed with. The requested media could be only online. For instance, it could be online commercial, but the media could be anything under the sun. TV, digital services, social media, and physical copies, for instance, for a movie. Movies usually cover all those media types. Another important term you need to pay attention is the term of use. Sometimes they can request limited use for 6 months or 1 year. If you're clearing a song for a movie, you would usually be requested to provide license for life of copyright. The territory is also very important. The larger the territory of the license is, the higher the fee should be. For instance, if the request covers only the territory of US, then you can ask for a lower fee. And of course, the budget of the production is very important. As I mentioned, if we have an independent movie with a budget of less than $1 million, you cannot really request a very high fee. But if they have 20 or more $1 million, then you can ask for more money. And one very important thing about the synchronization, if your song is included in the movie, please make sure that the song gets into the so-called cue sheets. Cue sheets are prepared either by the producer or a collecting society, and the cue sheets list all the music that is used in the movie. This could be original cues and also pre-existing songs that are cleared for that movie. Once your song is listed on the cue sheet, that cue sheet is distributed to all collecting societies in the world, not just BMI or ASCAP. They send this cue sheet to their sister societies in the world, across the world. And if the movie is broadcast in another country, then you can collect performance royalties from that other country. Okay, can you use somebody else's work? And what do you need to do if you want to do so? The general rule is always to seek permission. If you want to use somebody else's work and create a new work based on a pre-existing work, there are some exceptions to that rule. And in the US, this exception is the fair use rule, which I will focus on the next slide. Also, there is a few sections in the Copyright Act that exclusively set situations in which users do not need to ask copyright owners for permission to use their works. And I'm mentioning here 2 examples which are very common in the music industry of when somebody needs to use pre-existing work. One of them is samples. This is when an artist wants to use a pre-existing song or just a snippet of that song in his own new song. That snippet could be only from the composition and not the recording, but he can also use both the composition and the recording. In that case, they need to get permission both from the copyright owner of the underlying work and the owner of the sound recording. And of course, they need to pay fees for this permission. In those cases, when the new song is released with the samples of pre-existing composition, the authors of pre-existing composition receive copyright share in the new work and they collect royalties from each use. Another example of using a pre-existing work is cover recordings. If the cover is considered to be a straight cover, which means if you record a song without changing the lyrics, without any changes to the music, music, you can do so as long as you pay mechanical royalties, and you need to pay those either to the publisher or the Harry Fox agency. However, if you're making changes to the music, or if you're adding lyrics or translating them in a different language, you need to get permission from the authors, and you need to send them a copy of what that new work would sound like and maybe what the new lyrics will be about. I can here mention a very interesting maybe example, because cover recordings have existed for a long time, maybe many years, and back in the day they did not require permission for those cover recordings. As an example, the very famous song My Way, Frank Sinatra's song, is actually a French song. It's originally recorded in France and written by French authors, and later it was introduced to Frank Sinatra with English lyrics written by Paul Anka. I don't think at that time they requested permission for this from the original authors. However, the original authors received royalties from each performance of My Way, so they received their payment for that, so I think they were good with it. We mentioned fair use in the previous slide. I will dive a little bit deeper into what fair use doctrine is. So fair use allows us to use portions of a work in specific circumstances, such as criticism, comment, news reporting, teaching, and research. There is no clear rule what is considered fair use, which makes everyone's life a little bit hard. Rather than the U.S. courts use 4 factors in determining what can be considered fair use. And those factors are purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in the new work, and the effect of the use upon the potential market. So the purpose and character of use. This means that when the court, for instance, needs to consider if certain usage can be considered fair use, they will look at who used it, if it's a big corporation or who that used the work for commercial purposes, or educational institution that used it for educational purposes. They will look at it in a different way. Of course, it's more likely that the education purposes will be considered fair use and the commercial usage would not. The nature of the copyrighted work. For this factor, what's important is that the more creative and the more imaginatory the work is, the more likely it is that the usage is not considered fair use. If the work that has been used is factual or technical and less creative, then it's more likely that the usage will be considered fair use. With regards to the amount and substantiality used, the court looks at what portion of the work has been used up. For instance, 1 page or 2 sentences, but they also look at how substantial that portion is, because sometimes you can have very small parts taken, but that could be the heart of the work or the most important and recognizable part of this work. So in that case, even if the portion that has been used is tiny, it's still very significant, and it's very likely that this will not be fair use. And the last factor is the effect of that usage on the potential market value of the copyrighted work. In this case, courts are looking at the influence the new work will have on the market of the original work. That means if the newly created work is somehow hurting the market of the original work, and the original work cannot collect enough royalties or does not get enough recognition, and people prefer to purchase the new work that has been created. So if the market of the original works has somehow been hurt, then it is more likely that this use is not fair use. And from copyright, we'll make a big jump to trademarks. And I will touch briefly on trademarks, because there are a few important things that are important for musicians. First of all, musicians can register their names as trademarks. However, there are certain requirements for this. First, this can happen only if the mark is used on a series of creative works or it has a source identifying function. What that means is the mark needs to be used on a series of albums or recordings. For instance, you have to release an album or a single with this artist name in order for the USPTO to register your stage name as a trademark, or this stage name or artist name needs to be recognized by others as your name. And you can show that by providing, for instance, reviews from critics about your works. When you register a trademark, you need to list certain goods and services in your trademark application. And my recommendation is to try to cover not just sound recordings and live performances, but also merchandise, because nowadays a lot of musicians actually use merchandise as a very significant source of additional revenue. So make sure you have this on your trademark application. And another important note on trademarks is some people think that they can trademark the names of their albums or works. This is usually not the case. It's usually not allowed to do that unless the title of the work is used on a series of works. For instance, if you have a series of albums called Volume 1, Volume 2, Volume 3, and if they use the same title, or if you have a movie like Star Wars, they have Star Wars Episode number 1, number 2, then in those cases you can register the title as a trademark. But if you use the title for one single work only, you will not be able to register it as a trademark. And I think this summarizes all of it. And if somebody has questions, I'm happy to answer.
Thank you, Bojana, so much for your insight when it comes to copyright and licensing in the music industry. I recorded a jazz album recently, and before each song, I spoke about each song. Some of the information I got from different books, and on a couple of occasions, I recited short sentences from biographies of the authors. Would this be considered fair use, or would I have to contact the book publishers and authors and get permission to use the information that I got from their books?
I would recommend always get permission, just because there isn't, as I said, no clear-cut rule. If there is a dispute, you always end up in court and you have to rely on what the judges would say. But in this case, it seems that I don't think this could be considered fair use. So I would recommend clearing the rights for this usage.
If the author passes away, can a copyright in music be inherited?
When the author passes away, his heirs actually administer the copyrights on his behalf or on her behalf. And as I mentioned, the protection lasts for 70 years after the death of the author. So if somebody needs to use a work of the deceased author, they need to contact the heirs and get permission.
How long does the process take to get a song or composition copyrighted?
It's copyrighted as soon as you write it down. So if you write songs quickly, it could take one day. It depends on how quickly you can create a piece of work. If the question is about registering a work with the Copyright Office, it takes a few months. In the past, it used to take about a month or two, but lately there has been a backlog with the Copyright Office, so it might take up to, recently it took me about 9 months to register one work. I think it's faster now, but it depends a lot on how much work the Copyright Office has.
What about the 4-second rule for fair use, like music in a podcast?
There is no such rule. It's a myth. A lot of people think, not just here in the US, I've heard that in many countries, that people somehow believe that there is a rule that if you use 4 seconds, it's fine. No, it's not fine. And as I mentioned, if that's an extremely recognizable piece, or if those 4 seconds are extremely recognizable extract from the original work, this will not be fair use. So yeah, there is no 4-second rule, I'm afraid.
Thank you so much. That's actually the first time I hear that. So that's amazing that someone asked that. We have another question. We have recorded 5 albums with an engineer. The engineer didn't write any of the songs or any of the instrumental. Could he claim that he is a producer or an executive producer? Is there a contract that we should get him to sign?
Yes, please get a contract from him, because even if he didn't write the songs, he might still try to claim that he's a producer or an executive. Well, executive producer has a different role, mostly organizing the recording process, but a producer is the one who selects and tells you, can you record this again? Can you change this and that? Can you please sing this louder? And it has some creative choice. I don't know what the engineer in this case did. If he made this type of comments and actually was entitled to make some creative choices, then definitely sign a contract. But even if he didn't do so, I always recommend signing contracts, just because you can never trust people. If this is a successful album, they will try to claim percentage in any song, and because they see it's successful.
Thank you so much for that, Bojana.
If you are the copyright holder of a song that is remixed on TikTok and it goes viral, can you still receive the royalties?
If TikTok pays, I think TikTok has contracts with collecting societies. So if TikTok pays and they submit a report with your song there, yes. And you're a member of the organization that collects royalties, yes.
Thank you for that, Boyana. That was also a really great question.
I wrote the lyrics to a song, and my friend and his friends created the music and recorded it. I paid for the studio time, but they did not give me the rights to play the song. I then wrote a story about how I wrote the lyrics for the song from his encouragement. Do I have to share the story rights with him?
That's very interesting. Well, the story, as far as I understand, is different than the lyrics. So the story is, from what I see, maybe is the idea, and the lyrics is the actual work. So this is a very interesting case where we can distinguish between an idea and a work. So if I properly understand the question, one has the idea, but somebody else created the work. So in that case, probably the person who wrote the lyrics has the copyright. So that's how I see it.
Again, thank you, Boyana, for that answer. Follow up from the first question. I contacted the authors and they said to go through the publishers. When I contacted the book publishers, they said it was up to the authors. I'm not sure whom to contact or how to get permission for my project. Any recommendations on how to proceed?
Well, you did the right thing. Maybe if you get a written confirmation from each of them that they are not the ones to authorize this usage. It's very, very, confusing. And I've seen this happen, unfortunately, when you're trying to be legal and to follow the rules, but somehow it doesn't happen just because people are not responding or just they don't know what to do. At least you tried and you have record of that, and just keep copies of those emails. And if somebody comes after you, you say, I tried, I did my best, but nobody even responded.
What are the indicators that courts look at to claim that a copyright has infringed on another copyright?
Well, first of all, if we have a copyright infringement case, it needs to be filed by someone. And then the person or the company that files the copyright infringement, they claim that another work is a copy of their work. So what the court looks at are the similarities of the works. And they just compare both works. They usually hire experts and they make sure that the works are not independently created, because in the music there are quite many cases where songs sound similar but they have been independently created because the party that wrote one song never heard the previous one, and they can actually easily prove that because it's possible to prove that. But if you can prove that the infringing song was actually created based on your song and that the infringer had knowledge of the song that has been infringed and has heard it, then this is what you should look at to prove in court. And that's what the court looks at, this type of evidence.
Thank you for that. If someone records you performing a song live on their phone and uploads onto YouTube, is that song protected by copyright?
It is protected by copyright. And if you have noticed, for those of you who have YouTube channels probably have noticed that if they upload a content which is owned by somebody else, music companies now, they just file a claim saying, oh, this is my song, and I just collect the royalties for it. They don't make you remove it. Just all royalties from the performance of that song goes to them. And as a performer, if you don't like that performance, you can ask YouTube to take it down. Because if you think that the recording's not good, does not represent you in the best light, you have that option to ask always, saying they don't have the right to upload it.
Can someone successfully register a copyright on their own? Or do you recommend using an attorney to register a copyright?
I've seen both. I think it is a straightforward process, but I've seen people struggling with some of the questions and struggling to complete their applications. So it depends a lot on how comfortable you are and how much you would like to do research on your own. Lawyers usually do this for a flat fee because it's a pretty straightforward process. So for those who are not comfortable doing all the reading themselves and maybe getting it wrong, they can always hire a lawyer, and they can do that through California Lawyers for the Arts.
Thank you.
What happens when the copyright protection for a song expires?
It just enters public domain and it does not collect revenue from usage unless, the song, the underlying composition is just not entitled to revenue. However, if somebody records that song which is in public domain, they would still have rights in the sound recording and they can still collect revenue for that.
Okay, great. Thank you so much, Boyana. Your presentation was amazing. Thank you for your insight. Have a good night, everyone.